Hi, everyone. Good morning. My name is Andrea Chavarria, and I'm an immigration attorney. Today, we are going to talk about fiancé visas. I will talk a little bit about what is a fiancé visa, what are the requirements, what may prevent someone from obtaining a fiancé visa, and then we'll go through some other alternatives or options for individuals. So let's get started. Well, first of all, what is a fiancé visa? A fiancé visa is a visa that allows someone who is abroad, a foreign national who's abroad, to enter the United States to get married. So this fiancé visa, it requires there are several working parts with the fiancé visa. I like to say that there is a three-step process for the fiancé visa. So, like I said, fiancé visa is used for a foreign national to come into the United States to get married. Now, there are some other rules with this. One, the petitioner has to be a U.S. citizen. Then we also have to show that the two parties are free and able to legally get married, and that they have the intention to get married in the United States. And once you enter the United States, you have 90 days to get married. Fiancé visas have become a little bit more popular, especially after the show 90 Day Fiancé. That is a little bit dramatized, but some of the things are true and accurate. And so, fiancé visa, what is the first step? The first step is that the U.S. Citizen has to file what's called an I-129F petition. This petition is filed with U.S. Citizenship and Immigration Services. In this petition, we do have to show certain requirements. First of all, one, the petitioner is a U.S. citizen. We have to show, like I mentioned, that both parties are free and able to get married. So if you have gotten married anywhere else in the world, or you filed a petition for divorce, but it wasn't finalized, you are going to have issues. So if you've previously gotten married, you want to double check that you have actually finalized that divorce, because they are going to ask for it. Now, you also have to show that you have met in person within the last 2 years. There are certain exceptions to that. One would be if the U.S. citizen can show that he or she would suffer some hardship or extreme hardship in being able to actually meet their fiancé in person within those 2 years, or depending on the culture, sometimes it is known that certain cultures, or the two parties do not meet before marriage. But again, the general rule is that you have to have met within the 2 years prior to filing this petition. All right. So are there certain things that can prevent someone from applying for this petition? So when you file the I-129F, the application will ask the U.S. citizen if that person has ever had any sort of criminal history. Now, just because you've gotten arrested before doesn't mean that you will be ineligible to file this petition. It is all going to depend on what was the arrest for, and were you charged, and was there a conviction? Now, if you have been convicted for a crime that's listed under the Adam Walsh Act, you very likely are not going to be eligible to file for this petition. It's going to be a really big hurdle. Under the Adam Walsh Act, we are talking about criminal offenses such as sexual assault, abuse of a minor, kidnapping. Again, there's a list of offenses under the Adam Walsh Act. If you think that you may have been convicted of a crime that fits under there, it's very important to consult with an immigration attorney before going forward with this petition. Now, if you've been arrested or charged or convicted of a domestic violence case, that doesn't necessarily mean that you will be prevented from filing this petition, but that is something that could be heavily scrutinized. So again, if you believe that your criminal history could affect you from filing an I-129F petition, it is very important to talk to an immigration attorney before filing your petition. So this is the first step. As I said, for fiancé visas, I like to call it a three-step process. So first step is U.S. citizen files this I-129F petition. We've got to meet the requirements that are necessary that the government is asking us to prove with this petition. Now, once these petitions are approved, what will happen is USCIS, which again is U.S. Citizenship and Immigration Services, will then send that petition over to the National Visa Center. Now, this fiancé visa, as I mentioned earlier, is for a foreign national who is abroad. So the National Visa Center, which is part of the Department of State, will take over the case. Now, this is the second step of the fiancé visa. And this is all about the fiancé and is this person eligible and admissible to come into the United States. Here it is where you will file what is called the DS-160 application. So you will file a application for the fiancé with all of their information. You want to make sure it is accurate. You do not want to omit information. They will ask if that person has ever had any sort of immigration violations or any sort of criminal history anywhere in the world. And you do want to be transparent. We have seen issues where someone thought it was unnecessary to discuss or put in the application that, they previously had attempted to enter or had criminal history that they thought, well, it was dismissed in my country or it was in a foreign country, so I did not think that it counted. The government needs to know and wants to know about it, and if you omit it, they could think that you are misrepresenting yourself to obtain an immigration benefit, which makes it even harder to get your visa. So you want to be transparent about it. If you've had any immigration violations or any criminal history, even if it was arrest and the charges were dismissed, it's just something that you would still have to disclose to the government. And so if you find yourself in that situation and you have questions, consult with an immigration attorney. Better to be prepared and address the issue head on. All right. So as I said, step 2, the case is with the National Visa Center. So you have to submit the application, and then depending on the U.S. Embassy or U.S. Consulate where the person is located, each embassy or consulate does things a little bit differently. Either the applicant will schedule their interview, or the embassy or U.S. consulate will schedule the interview for the applicant. So once that interview is scheduled, the individual will go to the interview, and you're going to want to take certain documentation with you. And you still, again, will have to show that you are still engaged. You still have the intent to get married. You are free and able to get married, and that you plan on getting married within the 90 days of entering the United States. Go to the interview. If all goes well. Oh, and prior to that, you will have to get a medical exam. Prior to the interview, they do want to make sure that you have certain required vaccinations that are required here in the United States, and that you do not have certain public diseases that could affect individuals or the public here in the United States, usually like tuberculosis or syphilis. And also they want to make sure that the individual is not a drug abuser or drug addict. So lots of moving parts to get to the interview. Once you get to the interview, again, you will show the officer the evidence that's required and documentation. Then the officer will ask you questions to make sure that you are admissible into the United States. Like I said, if you do have some sort of criminal history or immigration violations, this is something that will be discussed during the interview. Now, certain immigration violations and certain criminal history we know will make the person inadmissible and just will not be able to enter the United States. But not every violation equals a denial. In certain cases, the individual may qualify for a waiver. And so this is why it's important to consult with an immigration attorney to determine if that violation, whether it's criminal or immigration, prevents you from ever applying for this sort of immigration benefit, or if you'll be eligible for a waiver. And you want to be prepared because that can prolong the case. So let's assume you don't need a waiver. You go to your interview. You've got everything in order. You've presented it to the adjudicating officer. The officer asks you questions and says, "Congratulations, you are approved." That's fantastic. You are one step closer to coming to the United States. So if you are approved at that time of the interview, what will happen is the adjudicating officer will take your passport. And the reason why is because, again, this is a fiancé visa. And in order to enter the United States, you need that visa to enter the U.S. Now, they need to print that actual visa with your information. They need to stick it onto one of your passport pages. and then you're able to enter the United States. And I know people get confused and sometimes ask, am I getting a US passport? No. This is your foreign national passport that you have shown to the government of the United States. They will take that, they will create that visa, put it on inside the passport, send it to a courier like DHL, and then the individual is able to pick up that passport with the visa and then enter the United States. Now, what happens once they send that passport and visa to the courier? Well, you're going to go pick it up and you want to double check the information on the visa. The reason why is if there is any sort of error, let's say a misspelling in your name, the date of birth, country of birth, we want to make sure that that is corrected by the U.S. Embassy or U.S. Consulate abroad before the applicant enters the United States. If you do not correct it before entering, it'll be a much bigger headache. So it is much easier to correct while you're abroad with the U.S. Embassy, U.S. Consulate before entering the U.S. So in this scenario, we assume applicant has gone to pick up their visa. They've double checked all the information, looks good, ready to go. Now, you want to also look at the expiration date. So these fiancé visas are typically issued for 6 months, which means that you've got 6 months to enter the United States. There are certain situations where the person may have less time. Usually we see this if there was some sort of issue in or delay in issuing the visa because of a medical issue or additional required documents. You want to look at the visa and you want to make sure that you enter the United States before that expiration date. What happens if you let it expire? Well, you're not going to be allowed to enter the United States with that fiancé visa. So you want to make sure that everything is planned ahead. So once that visa is issued, you have the timing right to be able to come into the United States. Now, the fiancé visa, it's very important to know that this is a single-use visa. What does that mean? Well, that means that you can only enter the United States once with that visa. So think about it this way. A tourist visa, generally you can come and go as often as you want. A fiancé visa, once you enter, that's it under that fiancé visa. So you want to, again, make sure that you have everything planned for your arrival into the United States. And I know this can be a really big thing for people who are planning on moving to the United States. So you want to have, again, be prepared, have that plan, have everything organized so when you enter the United States, you can move forward to the third step. All right, so you've got your passport on hand, you've booked your flight, you're ready to come into the U.S. So once you come into the U.S., you're either going to likely fly here, or if you're in Canada or Mexico, you could go through land. So you go through a port of entry. Officer is going to look at your passport, look at the visa. As long as there is no fraud, as long as you haven't been charged or convicted of a crime in that time frame between getting the visa approved and entering the U.S., everything should be good, and you're allowed to enter the United States under what's called your K-1 fiancé visa. Once you're in the U.S., congratulations, you're almost done with this case. So, very important, like I mentioned earlier, when you're applying for the fiancé visa, you have 90 days to marry once you enter the U.S. So that's extremely important. It does not mean you have 90 days from the expiration of the visa. It means you have 90 days from the day you enter the U.S. So let's say you were given the 6 months to enter into the United States. You cannot wait to see your loved one and be with them. So you decide 2 weeks after the issuance, you're going to enter the U.S. That's perfectly fine. But again, once you enter, that clock starts ticking. So 90 days to get married. You want to make sure that depending what your plans are on getting married, that you already have started organizing things, because depending on each state, everyone has different rules. So here in Texas, for example, you've got to apply for your marriage license first. There's a waiting period, a few exceptions of waiving the waiting period, but typically apply for the license, then you've got your waiting period, and then you can get married. And so if you are waiting till the last second to get married, that could affect you if you don't meet the deadline. So 90 days to get married. You come in, you decide, all right, we're going to get married in 1 week. Perfect. You get married. What happens next? Well, once you've gotten married, you can now move on to the third and final step, which is applying for your lawful permanent residency, or as many know it, applying for a green card. So, the fiancé visa is utilized in order for the foreign national to come to the United States to get married. Once that person comes into the US, then we can apply for this green card. So, the lawful permanent residency that is filed with US Citizenship and Immigration Services. So, remember when I talked about that I-129F petition at the beginning, this is going to be the same adjudicating agency, and that is here in the United States. So, a lot of other one of the important questions that I get is, can I travel outside the United States once I've entered the US with my fiancé visa? No, until you get or apply for a advanced parole uh, you get advanced parole granted. When you have advanced parole, which means you generally apply for it once you've applied for residency, then you can travel outside the United States. But meanwhile, you cannot travel. You have to have that advanced parole document. Now, can you apply for a work permit? Yes, as soon as you enter the US with the fiancé visa, you can apply for that work authorization. But and it all is going to depend on the timing. A lot of individuals like to come in, get married, and soon after apply, within a month or less, apply for that a residency card. So you can apply for your employment authorization under the fiancé visa, or you can wait and apply for it under the residency application, which you'll have a longer time with the work authorization if you applied through your residency application compared to applying for it with under the fiancé visa, which you only get 90 days of employment authorization. So that's another motivating factor for certain individuals to apply to get married quickly and apply for the residency application. So there's so the fiance can have have in process their work permit and their travel permit. So file that green card application, you file your travel permit if you want. Other individuals, it's not required. Certain individuals prefer it, others don't, and apply for that work permit. So what happens next? We wait. We wait until USCIS adjudicates the application. Depending on USCIS, they could waive the interview. Right now, we're not really seeing interviews being waived. Generally, there is an interview. And so at the interview, the adjudicating officer is going to, again, make sure that this is a bona fide marriage, that the person is still admissible to the United States. So if the person comes to the United States and starts committing crimes, gets arrested, obviously that could affect them. If they travel outside the United States and come back unlawfully, obviously that's going to affect them. So they just need to make sure that there aren't certain immigration violations or criminal offenses that could affect their residency. Or also make sure that, they came with the intention to get married, have gotten married, and are still in this bona fide relationship. So once the person goes to their interview, hopefully they get approved on site. But most of the time right now, we're not seeing that. What we see is generally the officer will say, I need to review this case, or I need to confirm with my supervisor before I can make a decision. That's okay. Doesn't mean there's anything wrong. And then receives the decision by mail. So once that happens, the individual is then going to get their residency. Now, how long have you been married before you get your residency matters. So, like I said, we filed that fiance, the I-129F petition, then the fiance visa, then you enter the US, you file for your residency card, and now you've gotten approved. But you have only been married for a year before they granted your residency card. Why does this matter? Well, the law says if the individual has a residency has been married for less than 2 years before getting their residency application, that person is going to before getting their residency, then that person is going to have a 2-year residency card. Now, the reason why they do that is to make sure that, again, this was only this was a bona fide marriage. The intention of getting married was always about being in love and being in this relationship, not simply to bypass immigration laws. So that's a really important thing to keep in mind because after the so if your residency card is issued for 2 years, what that means is 90 days before the expiration of your residency card, you are going to have to file what's called an I-751 petition to remove those conditions. And what does that mean? Well, it means that you're going to have to prove to the government that you are still in this bona fide relationship. So you file joint tax returns, you're living together. You've basically created this life together and it is a valid marriage. So, immigration, this is a pretty long immigration journey, but it is a viable option for many people who want to bring their fiance over to the United States, but don't want to get married yet. They want to bring them here. Once they're here, get married and then go through the process. So, a lot of people like to use the fiance visa in order to get the individual into the United States first. And that's understandable. Other people decide, well, that's too many steps for us. We would prefer to get married first and then go through what's called the consular processing in order to obtain the residency abroad and then come into the United States as a lawful permanent resident. So again, this is something that you would want to discuss with your loved one, especially when we're talking about marriage. And we know that marriage is something that's very important to everyone and sacred. And so you want to make sure that, if it's important for you to get married, with all your family, are they able to attend where it is that you're going to get married? Does it really matter to you if you get married, here in the United States or if you get married abroad? So these are things to discuss with your fiance or your loved one if you're thinking about getting engaged. And, are you okay waiting a little bit longer for that person outside the United States, or would you prefer for them to enter the US first as a fiance and then get married and go through the other procedures? Now, um, the good thing about getting your residency as a through a US citizen is that you can apply for US citizenship in 3 years. So there are certain benefits and like I said, the fiancé visa is an option for many. It's just going to depend on each couple and what they prefer. So if you have any questions, of course, you can always call our office at 972-827-8359 to schedule a consultation. Now, I know I have a list of questions that people have provided to us, so I am going to go through them and try to answer some of these questions. So, we've already discussed the eligibility requirements. One of the questions that we have here is how do you prove the relationship is real? And so, this can be a little tough sometimes because you're not yet married when you're engaged. So, a lot of times we have to show, the itineraries. When you're U.S. citizen, the U.S. citizen petitioner has gone to visit the foreign national, or if the foreign national has a tourist visa and has entered the U.S., we want to show those flight itineraries. We want to show that they've met in person. If the U.S. citizen purchased a ring, let's say here in the U.S., you have a receipt. The government wants to see photos, not just of you two, but that you've met each other's family or friends, if it's possible, obviously. Um, so that's ways to prove it also through technology, through phones, I know oftentimes WhatsApp is a popular form of communication. So that's another way to be able to prove that there is a relationship that you guys have met and that there is this intention to get married. Now, how long does the process usually take? So it kind of depends. Again, we're going to go step by step. So the I-129F petition right now is taking approximately 8 to 18 months. You need to check the USCIS website. The processing time can fluctuate. So sometimes we do see petitions that are processed a bit faster, others that are a bit delayed. And sometimes there's just no rhyme or reason. It's processing, unfortunately. And, it just, it's the time frame that it takes USCIS to adjudicate these cases. But that's an approximate average of what we're looking at for the first step. Once that is approved, then, like I said, they're going to transfer it over to the National Visa Center. Usually, once they approve it, hopefully that should take 2 to 4 weeks. to get to the National Visa Center and for the National Visa Center to communicate with you. If they haven't communicated, then normally we reach out to them and say, hey, this petition was approved. We haven't heard from you. We want to get this case moving. So once the next step I said is the actual filing of the fiance visa application, and then either scheduling the interview or the U.S. Embassy or U.S. Consulate abroad scheduling that interview for you. And that can vary. We've seen some cases where they've been scheduled within a month or two, others where it has taken a little bit longer. And again, this is all going to depend on the U.S. Embassy or U.S. Consulate abroad and their scheduling calendar. So sometimes the person can come into the United States very quickly. Once that person enters the United States, then we file the residency application with U.S. Citizenship and Immigration Services. And here we've seen a variation. We've seen certain cases where once we filed it, we've gotten an interview scheduled within 2 or 3 months. And then there are other cases that have been pending for close to 12 months. So again, it's just going to kind of depend on the processing time from USCIS and how fast they're working on the case. And for the interview, the local USCIS office, how far out are they scheduling interviews? So it varies by city and location. But overall, we could say maybe this case could take about 1.5 to 2.5 years potentially. Some could go a little bit faster, some could go a little bit longer. But that's generally what we're seeing at the moment. All right. So another important question, what if we don't get married within the 90 days? That is not a good thing. So if you do not get married within the 90 days, you can still get married, but your spouse is going to have to leave the United States and consular process and get their residency abroad. If you don't get married, the person the fiance who entered with the visa, then at this point you are violating immigration laws because now you're accruing unlawful presence because your visa has expired. So it's extremely important to meet that deadline. And we also understand that sometimes, someone falls in love, they want to get married, they come into the United States, and unfortunately, the situation is not a good situation. The U.S. citizen ends up being abusive. If that happens, there is a possibility that you could apply for a U visa. And unfortunately, that is a situation that can sometimes happen. But there are alternatives if you do end up in that sort of situation. And when the U.S. citizen files that I-129F petition, this is why they scrutinize cases with individuals who have domestic violence cases, because they want to make sure that the foreign national who enters the United States is not going to find themselves in that type of situation. But we know that, unfortunately, these cases do happen. So if you are the fiance, you've come here and you are facing that situation, if you are in an abusive relationship or situation, you do want to call the police, and there is that potential for filing a U visa. But generally, if you do not get married within those 90 days, like I said, if you want to still get that residency, you're going to have to depart the United States and get your residency now through consular processing. All right. Can the fiance travel outside the U.S. after arriving? As I've mentioned before, no, until you have that travel permit. It is extremely important that that travel permit has been granted. You need to look at the dates that you can depart and when you have to return. If you leave beforehand or you leave and your travel permit has expired, then at that point, you will very likely be denied admission into the United States. And if your residency case is pending during that, it's going to be deemed abandoned. So there are risks if you travel, obviously, like I said, before getting that advance parole granted, or if you let it expire before you let it expire while you're abroad. Okay, so other question, what happens after the wedding? Well, after getting married, like I said, you file for your residency. All right, can children come with the fiance? Yes, they can. And They can, as long as they are under 21 years of age and they are single. And so this is something that, again, you need to discuss as a couple. We've had situations where the US citizen petitioner says, I want to bring my fiance and I want to bring her kids. Perfect. Let's go through the fiance visa route. There are others who say, first I want to bring my fiance over, and then once she gets her residency, I want to file for the children. That's fine. You can do that, but that would be through consular processing, and that's a completely different application and route versus the fiance visa. So again, something that you want to talk about as a couple, especially if you have children, and again, they're under 21, they're single. If they're very little, obviously you would. The idea would be that you would want to bring them, but again, every family is different. That's gonna be something that you guys will have to discuss, but as a fiancé visa, yes, that is available for the children. Now, what are the biggest mistakes people make? So, one of them is not understanding the fiancé visa. Like I said, coming to the United States and thinking that you can use this visa kind of like a tourist visa where you can leave and come back multiple times. That is not correct. A fiance visa is a single entry visa. Another one, a big mistake, is not having all the documents ready for your application for your interview abroad with the U.S. Embassy or U.S. Consulate. So there are some financial documents that are going to be needed from the U.S. citizen to show that the fiance, and if you're bringing the children, that they're not going to become a public charge to the U.S. government. So these are some mistakes that we see with certain cases. Now, additional questions. Can same-sex couples apply? Yes, you can. So if you, again, have your fiance and you would like to bring him or her over and you're in a same-sex relationship, that is completely fine. And like I said, you still have that 90-day requirement to get married once that individual enters the United States. Can my fiance visit me while the fiance visa is pending? So, if the I-129F is pending and your fiance has a tourist visa, yes, they can come visit you. Now, will they potentially be scrutinized? Yes. So, when they enter the United States or try to enter the US with their tourist visa, the officer may ask questions because they'll see that this application is pending and they want to make sure that the person is not using that tourist visa simply to come into the United States and remain here. So, yes, they can, but you will have to explain your motive or reason for coming to the US and understand that there is that risk that they could deny entry if they think that you're coming here simply to overstay. All right, can we get married outside the US instead? So, you under the fiance visa, that would be a no because again, you have to use that visa to enter the United States and that visa is only used as a single entry. So once you enter the US, you have to get married here in the United States if you want to continue through that route. Now, if you decide, you know what, I don't want to go through the fiance visa anymore, or, we've decided we want to get married abroad, that's okay, but you're going to have to start a different process. You're going to have to start a family based petition for your spouse once you get married abroad and then go through that route. So, our advice generally is if you're doing the fiance visa, understand you're getting married here in the United States. If you decide to get married abroad, that's okay, but you're just going to have to start a new petition, family petition, once you get married. Another one, what if my fiance has been denied a visa before? So that doesn't necessarily mean that the person will not be eligible for a fiance visa. What if that if a visa has been denied before, my recommendation is consult with an immigration attorney because we want to know what was the reason for the denial. Oftentimes, we do see where a tourist visa has been denied because they think maybe the person doesn't have the resources or the funds to travel. That's okay. That's not going to be an issue. But if the visa was denied because, let's say, the person has already lived here in the United States, or they had some sort of criminal history, or they committed some sort of fraud or misrepresentation, well, that's going to be a bigger issue. So doesn't necessarily mean that your fiance visa will be denied, but we do need to know why was it denied, and is that something that's going to harm your case, or is it something that will require a waiver? All right, another question: can we file the paperwork ourselves? It depends. Some people prefer to go through an immigration attorney. Again, we have the experience, we deal with these types of cases. Other people decide, I want to do it myself, and that's okay. You can do it yourselves. But if you have any sort of immigration violations, any sort of criminal history, these are cases where I would highly recommend consulting with an immigration attorney first before deciding to file something on your own. Or, immigration, they can look at certain cases where they think there are red flags. For example, a US citizen who maybe has gotten married multiple times and applied for each of those individuals, that's a really big red flag for them. Doesn't mean that the US citizens' marriages weren't legitimate, but that's a concern to the government. So there are these sticky situations where, if you try to file on your own, you might not realize that, your case may get a little bit more complicated or delayed, or you may not even be eligible to apply for this benefit. So, yes, you can try to file it yourselves. Our recommendation is, at least if you're thinking about it, try to consult with an immigration attorney. So that's all we have for today. Thank you for being here with us. If you have any questions and would like to consult with us, please call us at 972 827 8359. Thank you, everyone.